Well, hi everyone. I'm just going to make a quick improvised video about the Commonwealth Ombudsman's report, which was published yesterday, the 2 August 2023, entitled Lessons in Lawfulness. It's a fascinating report in the wake of Robodebt, and I, for one, being very heavily involved in the welfare law area, was completely unaware that this report was being drafted, or that the investigation from which it flows was being undertaken. So I thought I'd just make a quick video, which is often a lot faster than writing something, to run through some of the salient features of this remarkable report, which seems to confirm that many more debts that were calculated by the Department of Human Services, now Services Australia, and the Department of Social Services, were unlawful beyond what have already been recognised as Robodets. So I'll just take you through some of the information provided in this report. So first of all, Services Australia and the Department of Social Services were in contact with the Commonwealth Ombudsman very recently, only just a few months ago in February 2023, and it had confirmed that it had been apportioning income, which I'll explain soon, to calculate social security payments before 7 December 2020, when an amendment was introduced into the Social Security Act that seems to have rendered that practice of income apportioning lawful. But before 2020, without that amendment having been inserted, it was not lawful. And Services Australia and DSS confirmed as much in February 2023. So the report is at pains in this highlight section to make the point that income apportionment is different to income averaging, which was the nature of the methodology used to calculate Robodets. However, as many will be familiar, the words income apportioning were used at the early stages of the Robodebt Royal Commission, and effectively the technical basis upon which income apportioning is carried out is not itself different from income averaging, but rather, in my view, the source from which the figures are drawn tends to be different. So rather than collecting information from the ATO and creating an average over 26 fortnights in order to work out then a daily rate of payment as required or as enabled by the internal calculators at Centrelink, with income apportioning, which this report focuses on, what's happening is income details are either reported by the Centrelink customer or they are verified by the employer, but sometimes those reports or those verification forms do not include, one, fortnightly figures. So, for example, an employer might pay a recipient of Centrelink income wages on a monthly basis or on some other basis that doesn't easily fit into the entitlement fortnights that Centrelink requires a person report their income for. Or secondly, a person might report their income on a fortnightly basis, but those fortnights do not align with the entitlement periods during which Centrelink calculates the entitlement. And as a result of this misalignment between the entitlement fortnight and the income fortnight, and the mathematical problems that creates, the departments have used an apportionment method that in some cases, and I suspect very many cases, results in 2 fortnights or more fortnights being averaged across that full 28-day period, meaning that you effectively get the same multiple or successive fortnightly averaging occurring as occurred over 26 fortnights in Robodebt, but now you might have it only over a couple of fortnights, or 3 fortnights, or 4 fortnights, or so forth and so forth. So, to my mind, the theory and methodology by which income apportioning occurs is no different at the level of at technical calculation to the Robodebt income averaging, except that you're drawing the data or the quantity of income from different sources, and there are different reasons why the calculation doesn't align with the entitlement period. So it's not ATO extracted or derived figures that we're dealing with in terms of these income apportionment debts that are now regarded as unlawful, but according to the Ombudsman at least, we haven't had a curial or judicature, a judge, say that this is unlawful. So it's quite remarkable in my view that the Ombudsman is so confident in making a statement that this is unlawful in this report. Speaking hypothetically, I would be very surprised if the Ombudsman did not have extremely clear legal advice that it was unlawful in order that it can then quite positively assert with all of the liabilities, both legal and notional, that such a statement entails. So let's have a quick look at the report. I've already started to explain it well before I've actually looked at the text. But we have a situation in which the debts I've described, non-Robodets are also as unlawful as Robodets in terms of the way they were calculated. So this is a hugely ramifying report for potentially many thousands, perhaps hundreds of thousands of debtors from at least as far back as 2003. Okay, so 20 years of unlawful calculation of welfare debts across the Commonwealth of Australia. So let's have a quick look at the text a little more. So, let's go down to what did we find. So the findings of this report are as follows. Since at least 2003, SA, formerly the DHS, was unlawfully apportioning customers' income across 2 or more Centrelink instalment periods. And I'm calling those entitlement periods, but it's the same thing. This in turn likely affected social security payment rates and may have led to unfair debts against customers. Well, one supposes that if they are unlawful debts, they're almost certainly unfair debts. Since becoming aware of the issue in October 2020, the agencies, that being Services Australia and the Department of Social Services, took steps to seek legal advice. But as this report makes clear, they could have acted more quickly or quicker to finalise this advice. And as we'll see, there is still an unresolved and significant difference of opinion between the two agencies' legal advices. So we're in a situation where the Department of Human Services, now Services Australia, has legal advice X, and the Department of Social Services has legal advice Y. I'm assuming that legal advice is relatively high-powered. You would expect that if you have contrary advices and neither agency is ready to accept the other, that they are equally high-powered. And by high-powered, I mean you might have senior counsel writing advice in relation to this matter. That's all assumptions and hypothesis, of course, but the point I want to make, and that is made here, is that there's an unresolved and significant difference of opinion between some of the legal advisors proffered by lawyers, professional practitioners, retained by the agencies. The general instructions that DSS developed to guide how decision makers should recalculate what have been the discovered pool of approximately 100,000 actual and potential debts needs further development. So it seems that DSS have come out on the front foot since October 2020, and they've developed a guide for how decision makers, and now I assume they will be AROs or subject matter experts. These are the two internal reviewers that are made available to Centrelink customers when they seek review of any debt. So these reviewers have a guide now which enables them to understand how or if to recalculate something like the 100,000 actual and potential debts that have been discovered and which are affected by this unlawful calculation method. But the report says that the agencies could have acted quicker, once again here, to inform the Commonwealth Ombudsman of the issue that they have been working on since around this 2020 period. And particularly it says that Services Australia should have acted quicker because it knew that the Commonwealth Ombudsman's office had already begun to investigate some of the affected complaints. So, I mean, you have a situation here where the Ombudsman has asked Services Australia to respond to its queries with respect to certain complaints that had been made to it as a Commonwealth Complaints Agency. And Services Australia has effectively delayed and deferred its response, and the Ombudsman criticises Services Australia for doing as much in the report. Finally, its summary of findings, it says that the agencies are still determining, this is Services Australia and the DSS, are still determining how much the known and potential debts are affected. In other words, how much payment rates went up or down because of unlawful or inaccurate income apportionment calculations. It is unknown how many other customers may have been impacted by unlawful or inaccurate debts or underpayments. Okay, so this is an interesting situation because, as we've learnt from Robodebt, and as this report kind of suggests, lessons in lawfulness, as we are still continuing to learn, when a debt is wrongly calculated, especially if it's in the past, and several decades potentially in the past, going back to 2003 here, it is very likely that the employer who originally paid the recipient of Centrelink income, and by doing so kind of altered the Centrelink recipient's entitlements to social security payments, that employer is no longer maintaining records that far back, and so cannot furnish any more evidence than they already have, or that employer is long out of business or has gone through different management and ownership setups, and so when it comes to recalculating a debt that might potentially be 20 years old, it's very unlikely that there would be any better evidence available than what has already been given to Centrelink. So I am not sure how you could plausibly think that some of these older debts could be calculated. And the reason I say that is because it's not simply the method that was administered or was applied to these debts that needs to be changed to suddenly magically make them lawful. What has happened is that the method has been applied to these debts because of the nature of the evidence that originally fed into the calculator. In other words, when an employer reported to Centrelink, usually on a kind of on-request basis from Centrelink, an information gathering power basis, then which Centrelink uses to seek information from employers, and that's what happened before Robodebt very often. When that occurs, the employer will give everything it can to Centrelink, and sometimes that will be records of income being paid to a person on a monthly basis or on a lump sum basis at irregular intervals. In other words, that's the only records they ever had, and there were no records that could be used to allow Centrelink to get these nice fortnightly entitlement periods lined up with the income receipt periods in order to recalculate them in the way that would be lawful under the Social Security Act prior to 2020. And so this notion that's raised here in the Ombudsman's report, that the agencies are still determining how much the known and potential debts are affected and how much the rates went up or down, and how, by implication, to correct these amounts. Because if you're talking about amounts by which things went up and down, you're really trying to correct the debt. And as I've said, how could you correct a debt where the evidence is not sufficiently substantive or probative or detailed to enable the legislative requirement to calculate income earned within an entitlement fortnight to occur? That's what the legislation required, that the income be calculated when it was received within the fortnightly period. If you have an income record that doesn't give you specific details about when the income was earned, and therefore allows that fortnightly entitlement period to be carved out and separated from another lump sum or something, then it's just insufficiently detailed to enable the calculation under the Social Security Act to be applied. And that is the fundamental problem that has existed for many decades. Centrelink never was able to, in these kinds of cases, create an internal calculator or a process by which ambiguous data was, or to put it in those terms, or insufficiently detailed income data could be converted to sufficiently detailed data for the purposes of the legislative provision, which we'll come to. So I'm just, speaking off the top of my head here, extempore, but I hope that it's coming. Some of the information is coming across clearly. So that's the summary of findings that we see here in the report, and it goes on to give a lot more detail. Some of the interesting facts are, in the following pages. There's a bit of background. The provision of the Social Security Act that is, kind of in focus here is this 1073 capital B. Okay, now 1073 capital B was in force between 2003 and 7 December 2020. They haven't been specific about which date in 2003 it came into force. I assume that could be discovered. Maybe they've just not done so for brevity purposes, or not specified so for brevity purposes. But there is suggestion in the report that it's not known whether such debts go back further than 2003. So maybe the ambiguity here spawns from that very notion that these unlawful debts go back at least to 2003, and it's not being specific here because it's too kind of ambiguous as to when this section was in force, or alternatively whether a preceding section in similar terms was in force earlier. In any event, the Office of the Commonwealth Ombudsman, prompted by some of the Senate estimate concerns, some of the concerns raised in the Senate estimate hearings by Senator Rex Patrick and others, prompted the Commonwealth Ombudsman to investigate a number of complaints that I understand would have been referred to it by the Senator Patrick, but might have also been kind of brought to the attention of the Ombudsman's office by the complainants themselves. Between that date in 2021 and January 2023, the Ombudsman's office, without any kind of public kind of statement that it was doing this investigation that I'm aware of, but it could have been out there, investigated and made preliminary inquiries about those complaints. During this whole period, Services Australia did not inform the Ombudsman's office, even though the Ombudsman was investigating these complaints and asking Services Australia for information about its methodology and the like, that there were delays in reviewing current Centrelink customers' debts, precisely because Services Australia was itself investigating this underlying issue of apportioning income. In other words, Services Australia was doing getting its own legal advice and doing its own investigations internally with respect to the issue that the Office of the Ombudsman had raised, but it did not inform the Office of the Ombudsman that it was doing this investigation of its own, nor did it tell the Office of the Ombudsman that it was delaying the review of any potentially affected income apportionment customers' files, because it was kind of undertaking its own review. And obviously, if the Ombudsman was saying to Services Australia, we think we have a problem here, and Services Australia was thinking, well, okay, we're getting information that there might be a problem here. What are we going to do about it? Oh, and meanwhile, we've got hundreds, perhaps thousands of files coming through that are seeking review with precisely the problem that the Ombudsman is saying is a problem. What are we going to do? And it seems to have taken 2 years of cogitation and investigation for Services Australia finally, in January of this year, 2023, to approach the Ombudsman and say, look, we've now got some information for you on that question that you began asking back in March 2021, and here's our briefing to you. So Services Australia offered their briefing to the Ombudsman in 17 February 2023. This is during the hearings of the Robodebt Royal Commission, and it's during the Commission's activities. I'm sure that the government must have known about this issue too. After all, Secretaries of Services Australia and Secretary of DSS must have been in contact with the ministers. So I find it quite astounding that in parallel to the Robodebt Royal Commission, there was this other issue bubbling away, and none of us who were commenting on the Robodebt Royal Commission seem to have known or heard of it. And so anyway, in that briefing of 17 February, Services Australia and DSS told the Ombudsman a number of key things. Firstly, that they had obtained several draft and final advices from multiple legal providers. So obviously over that time, they've received advice. Second, that they've identified approximately 13,000 review requests that may be impacted by income apportionment. So before when I said hundreds, maybe thousands, it was actually 13,000 requests for reviews of debts that the agencies themselves had identified as impacted or affected by the income apportionment problem. Thirdly, and they had put them on hold. Now, I'll speak less formally here and just make a note that I'm aware of at least one person who I've been in contact with over the whole Robodebt period, so late 2022 to the present, and before the Robodebt period, so probably going back to the start of 2022, who has a debt about which they are very suspicious, seemingly because of some of these, kind of successive numbers across multiple fortnights, where you've got the same number across multiple fortnights as your income, suggesting that there has been apportionment. And because I'm kind of, focused on a bit of the welfare law and certainly Robodebt, that person has come to me and on multiple occasions said, I still haven't got my review. I still haven't had my review. And multiple times I've said, I cannot believe that. I mean, I've heard 6 months delays where people are getting 6 months delays before they get a subject matter expert, which was kind of, in my view, introduced to manage the delay, because originally it was just you had an ARO, an authorised review officer, and that subject matter expert didn't exist. And I've expressed before my view that I think the SME was introduced to kind of manage the volume of review requests that the agencies were receiving. But I'd not heard of too many instances in which there'd been more than 6 months, and certainly not more than a year of delay between the review request and the SME, and nor the ARO. And so I said to this person, you must kind of write a letter copying, the minister and everyone else in to ask why such a delay has occurred. And I didn't take it upon myself to look any closer at the person's file or anything. I offered to, but it seems that I'm not sure if they did that, but obviously, it's not until very recently that any kind of conclusion as to the nature of this problem has been reached within the agencies, and that's 17 February. Then they've gone to the Ombudsman and said, okay, there's 13,000 on hold, and we, as the agencies here, have identified approximately 87,000 potential debts which may be affected by income apportionment. 87,000. So it's almost 100,000. Now, that's the potential debts that the agencies have identified as those that may be affected by income apportionment. It's not clear in this report on that figure whether that is debts already repaid or debts still in dispute, etc., etc. Bearing in mind that the law was changed in 2020 so that they would have been debts either calculated before that 2020 amendment or post that 2020 amendment. I'm not sure. It just isn't clear to me at this on this page at least whether those 87,000 are unpaid debts, paid debts, debts on review, etc. So on the following page, there's a kind of timeline which is helpful if you want to understand the way in which things moved along and led to this report. But I guess the top line point is that it began in October 2020 with the Senate estimates, and it wasn't until February 2023 that DSS and Services Australia got in touch, or until March 2023, got in touch with the Ombudsman to notify it of its advices and so forth. So you can see here you've got different firms, Firm 2, Firm 1, Firm 2, Firm 2, etc., giving different advices at different points throughout the period. And yeah, just another crazy, kind of surprise that this was occurring during the Robodebt Royal Commission. So what did the Ombudsman do? Well, it conducted a desktop review. Now, that's not defined in this report. What's a desktop review? A desktop review is what you've got on the desk. It doesn't go too much further than information that's kind of accessible and available. That's my kind of interpretation of that review. It doesn't say a comprehensive review. It doesn't say a thorough review or a methodologically validated review. It says a desktop review. That adjective means that it's a rough and ready review in my pejorative interpretation. It's a review that doesn't purport to be anything like a final review. It's on the contrary, a very kind of scope-oriented review, a kind of basic outline review. So the Ombudsman conducted a desktop review of the agency's response to its questions, including the agency's legal advices and other information provided to it in response to a notice that the Ombudsman had formally served, as it were, or gave to the agencies pursuant to its statutory functions and its the relevant act appertaining to the Ombudsman's establishment, and specifically Section 9 of that Act, which, without going to the Act, would enable it to serve such notices on relevant bodies investigable by the Ombudsman. So after issuing that Section 9 notice, which asked the agencies to give it more information and ask questions as part of its investigation, and this is the information it did the desktop review of. The Ombudsman found that Services Australia and the DHS, which preceded it, had been spreading employment income evenly over 2 or more Centrelink instalment periods or entitlement periods, named Centrelink fortnights here, in circumstances where this was not permitted by social security law. Very simple. Now, look, the Ombudsman has reviewed the legal advices, it seems, that the agencies have themselves received from its appointed and retained lawyers. It's not, it seems to me, the case that the Ombudsman has sought its own legal advice and made an independent determination of the unlawfulness of these debts. On the contrary, it has made a determination on the legal advice that the agencies themselves has received. Now, remember that wrinkle earlier, that tension between the agencies flowing from the fact that the legal advices are in conflict as between the agencies. Now, presuming that the Ombudsman has seen both of those contrary advices or multiply contrary advices, presuming there's more than 2 and many are in conflict, it has nevertheless, despite some, I'm inferring here, despite seeing the, let's say, favourable advice, any advice that might say it is potentially lawful, despite seeing that potentially, the Ombudsman has still, on its desktop review, determined that the agencies had calculated debts in circumstances where such calculations were not permitted by social security law. Okay, so the Ombudsman has made that statement here. As the report continues, this approach, which is known as income apportionment, could result in customers' employment income being assessed in the wrong Centrelink fortnight, which could in turn result in their fortnightly Centrelink payments being overpaid or underpaid. This methodology, it continues, along with examples of how it works and how it can affect entitlements, is explained in detail at Appendix A at the end of this statement. Now, thankfully, we finally have a government agency, and the Ombudsman is one, a statutory agency, creating a sheet or a piece of writing in which it explains why income apportionment is incorrect. Now, I think, or unlawful. Now, I think that the Robodebt Royal Commission was superbly well run, and the Commissioner, the Honourable Catherine Holmes, did a remarkable job, not only of conducting the commission, but writing the report. However, the report did not do a very it did not focus on the methodological defect that meant Robodets were unlawful. Arguably, it didn't have to, because the Federal Court of Australia, in the Amato proceedings that were settled and then reinforced by the determination made in the class action, had already explained the reason why the income apportionment or income averaging method used to calculate Robodets was unlawful. And so perhaps the Royal Commission didn't need to do that. But here, with the Ombudsman's report, clearly, you know, in a separate manner of investigating why these debts are unlawful, went further than the Robodebt Royal Commission, and even went further than the federal court decisions have gone in finding that they were unlawful and giving information as to why they were unlawful. And when we get to that, it'll be really interesting because I can explain it in more detail, but I did explain it at the top anyway. So the investigation of the Ombudsman also found these things. It found that the income apportionment issue impacted payment calculations from at least 2003, as I say, and went right up until the amendment to the Social Security Act in 7 December 2020. A range of payments were affected by this income apportionment problem, and look at them. They're here in Figure 2. Is there many payments that weren't affected before that March 2020 date? New Start, Job Seeker, Youth Allowance, AB Study, Oz Study, Special Benefit, Age Pension, Parenting Payment, Disability Support Payments, Carer Payments, etc., etc., etc. Even some coronavirus supplement payments, supplementary payments, etc., were indirectly affected. Okay, so this is across the board, really. Now, due to the number of payment types affected, this is very important in this report, and the length of time over which these income apportionment issues were occurring, there may be more customers affected than the 100,000 reviews and debt matters already identified. So isn't it interesting that we now have a figure of 100,000 emerging in this report, whereas earlier it was said that the agencies had said there was something like 87,000 potential affected earlier in the year, in February 2023, or whenever they briefed the Ombudsman. Now the Ombudsman, after its desk investigation, its desktop investigation, has expanded that number to 100,000. And, you know, it's tersely put. But in the context of the desktop investigation, in the context of receiving only information under its Section 9 power from the agencies and not taking up any independent investigation, and in the context of an ongoing investigation, which I haven't described, but I should make clear that there is an ongoing investigation here. This isn't the outcome. This is the provisional kind of statement. A number of 100,000 is identified, and it's not identified as an estimate. It's identified as the base number. So they've identified 100,000 in all of these circumstances: desktop review, limited information, short turnaround, few months. 100,000, we've got 20 years of all of these different payment types affected by this. And I've described the nature of the problem in terms of why apportionment occurred. It occurs when an employer pays in sums that are either longer than a fortnight, which is very common. You know, people are paid in monthly. People are paid commission payments at random times throughout the year, blah, blah, blah. And it occurs when people report their income in a way that is disaligned to the entitlement period in such a circumstance that information is limited, and therefore Centrelink must, to put it, you know, kind of bluntly, fudge the figures by apportioning across at least 2 fortnights, so that you have the same number in terms of a daily rate of payment occurring in more than 14 days. So as soon as you hit that 15 days, 16 days, 28 days, where you have the same daily rate, you've had apportionment occur. Now, 100,000, I am being bobbled here, but I am saying that there's at least 500,000. Okay, Centrelink Robodets at all the different kind of categories of robodebt. Remember, some had been completely uncooperative, and they had kind of pure robodebts. They'd never given any information in response to the debt letters or debt notices, the alleged allegations of debts. And some had tried to cooperate, and yet the remedy was still not, the debt was still not remedied, and it was still affected by by robodebts. So you had different categories of robodebts. There were really 4, but it was kind of like 1 and then 2A and 2B and so forth. Regardless of that detail, the total number of robodebts did not rise to 500,000. It was somewhere between 400, 450, maybe a little over 450,000. I can't quite remember the exact number. But I am saying boldly, and I'm predicting here and now, that there's more debts affected by this than there were robodebts. The value of the debts might be lower, and it's important to note that robodebts, many of them were completely written off, whereas some of these might be remediable. But depending on the nature of how these are remedied and how these debts are kind of retrospectively dealt with now and reviewed, and we've already seen in this report that the Ombudsman is recommending that the current guidelines given to authorised review officers and subject matter experts at DSS or at Services Australia are insufficient. So that's their provisional remedy isn't sufficient according to the Ombudsman. So depending on what happens next, we might see these debts completely written off, waived, or kind of repaid. Or we might see a long and highly resource-intensive process of attempts to recalculate these debts where possible, which would potentially involve going back to individual employers for individuals. Now, even if you were to say, okay, there's only 100,000, can you imagine how resource intensive it would be to attempt to recalculate 100,000 debts, some of which may be more than 20 years old, or at least 20 years old? I just do not see a way that this can be resolved expeditiously. But that's not really a legal question. What happens next might be determined by the nature of any legal outcome. For example, if the federal court were referred a question of law by the AAT when a test case arose, and a test case would be one in which a person, maybe one of these people waiting for a review, one of these, 80 odd, or no, it was 13, one of these 13,000 who had been identified as a person whose debt may be impacted by income apportionment. All it would take would be one of these 13,000 people to go to the AAT1 and then potentially the AAT2 if the Commonwealth resisted at the AAT1 level, and then upon having the AAT look at it, the AAT then referred it to the Federal Court of Australia. Then the FCA would be able to look at this from the perspective of the legal provisions and make a definitive statement and a declaration of the legality of these debts, and that might initiate a government process, just like it did for the Robodebt situation, to remedy these debts. That is very formal and expeditious, etc. But as it stands, until we have something kind of almost undisputable or unassailable, like a federal court order or a federal court finding, we're treading water, and who knows how this will be resolved. So if people are interested in this process by which the AAT might refer a question to the Federal Court of Australia. I have actually written a blog about it on my Welfare Law in Australia blog, and I've gone through the power that in the AAT Act that enables the AAT to refer a question of law to the Federal Court of Australia, and hypothesised a few things about how it would work. Because last time I reviewed this, back in 2021, in relation to Robodets prospectively, which were kind of still very much unheard of at that point, really, at least in terms of kind of their status as something that's definitively unlawful. Well, they were actually at that time already unlawful, but it was still earlier than, and the Robodebt Royal Commission was certainly not guaranteed at that point. But when I looked at this question, I discovered that yes, there are a few little ambiguities as to how these references operate. And when I did research to discover whether the questions of law had been referred to the FCA under Section 45 of the AAT Act before, I could only find 2 cases. And so I analysed one of them, which is Mentink here. So please have a look at that if you're interested. But going back to the report, the 100,000 debt matters that had already been identified by the Commonwealth Ombudsman is said to be, is characterised here really as just a conservative baseline figure, and there may be many more affected by it. And I'm putting it out there, 500,000. And I might even say we could be approaching 1 million. More than Robodebt, potentially twice as many as Robodebt. That's my unofficial prediction. Okay. So, I mean, the report goes on. I might do a second video because this is getting quite long about some of the other matters here. But, just to give a few top-line notes, Services Australia and DSS did take appropriate steps to seek legal advice once the issue was raised back in 29 October 2020. But there was delay in establishing the legal positions, and that's what this report notes. So it's a problem. As I've already addressed, the general instructions created by DSS to provide guidance to Services Australia, the other agency, and its decision makers, who are those subject matter experts, the SMEs, and the authorised review officers, the ROs, were, in the view of the Ombudsman, not sufficient. And the Ombudsman notes that they do not cover any potential underpayments which may have been caused by income apportionment practices. In other words, if people were underpaid as a result of income apportionment, underpaid their entitlements, that is just not considered in the guidance, which just seems ridiculous and totally biased. Because obviously, if you've got guidelines that tell you, oh, this kind of debt should be treated in this way, and it doesn't include the possibility that a person might have been underpaid by this process, when that possibility seems obviously to exist, you're clearly writing guidance that avoids repaying people. Now, that's an inference. I speak ex hypothesi as to the internal machinations of the agencies. But, I think it can be fairly inferred that the guidelines are insufficient in a way that is skewed away from paying entitlements that were potentially unpaid to a person, given the Ombudsman's report here and what it says. The Ombudsman says that the general instructions need further development to enable the agencies to provide assurance to the Ombudsman that its position on income apportionment is lawful and clear. What does that mean? That means that even what it's done to remedy this issue as of the start of this year in the form of creating guidelines is inadequate for the Ombudsman to feel satisfied that what they're continuing to do is lawful and clear. Now, fair enough, it sounds like they've paused everything, but, they've prepared something, presumably to take action sooner or later, and it still doesn't seem to be sufficiently detailed or compelling as to the question of whether its new method is lawful or not. Now, the Ombudsman comes out with suggestions, which is a lovely and mild way of making, I guess, recommendations. There are 4 of them. And I think one of them is in 2 parts. The first suggestion is that, and it's quite a funny one, if it's not a tragic one, it is that the agencies decide who is responsible for future significant legal issues reporting. In other words, when there is a significant legal issue in welfare law, who of the 2 agencies, Services Australia or DSS, is responsible for reporting that issue to the Ombudsman, to the Minister, and so forth. This is just clear to anyone who's been keeping up with Robodebt, a continuation of the Robodebt dilemma, where both agencies blamed the other, no one took responsibility, no one decided who had responsibility. In fact, both had decided that the other had, and you end up with this lack of coordination, lack of clarity, and a convenient way to de-responsibilise yourself as the secretary or as the kind of public officer within the agency. It needs to be done. A decision needs to be made, and an amendment maybe should be made, multiple amendments to the acts to enable the responsibility to be clear as to what happens and by whom when a significant legal issue arises. Now, the suggestion in terms is that Services Australia and DSS collaborate to decide whether to report further to the Office of Legal Services Coordination about broader Section 1073B issues. That seems to me that there might be ongoing issues, and I know that there are because the investigation is ongoing, but it seems to me that they're saying, now could you decide who's responsible, and now could one of you, whoever's responsible, make a commitment to report ongoing issues to the OLSC. What a mild suggestion. Could one of you put your hand up to keep in touch with the Office of Legal Services Coordination? Could one of you actually just, kind of keep us informed or keep the OLSC informed? That would be nice. Yeah, no further comment. It just seems unfortunate that such a suggestion has to be made. I'll put it that way. Comment 2, and this is not a suggestion. The comment here is that Services Australia failed to act in a timely manner to inform the Ombudsman of income apportionment issues, despite the fact that the Ombudsman had engaged SA on specific complaints related to the income apportionment issue. So I've already kind of suggested that was so, and the Ombudsman is just saying, look, you delayed and you deferred and you didn't keep us up to date, and we think it was a failure to act. There's more about that here. And here is something that's really close to my interests. Some of these debts that are affected by income apportionment will have formed the basis of a brief of evidence developed internally by DHS for the purposes of a referral to the Commonwealth Department of Public Prosecutions. And that brief of evidence would have been received by the CDPP and would have been assessed as having, sufficient prospects of a conviction and so forth to give rise to a criminal prosecution of the debtor. And some of those prosecutions, if not the vast majority, because notoriously welfare prosecutions are, almost unexceptionally successful and return convictions, would have led to convictions and potentially long community service orders and potentially custodial sentences, including under the relevant section 135.2 of the Criminal Code, Commonwealth, with a maximum sentence of 12 months imprisonment for any one count of the offence. And some of these may have had multiple accounts of an offence against the Criminal Code. under section 135.2. So what I'm saying is that it's possible, indeed, you would imagine, hypothetically, statistically probable, that people were imprisoned as a result of debts that led to prosecutions and convictions in circumstances where those debts were calculated using the unlawful income apportionment method. How many debts resulted in that occurring, and how many people, maybe not many, but how many people have gone to prison and lived in incarceration as a result of an unlawful income apportionment practice? And if that question is of any legal force or of any ethical force, why isn't it being pursued with alacrity, vim, and anxiety? Because it seems most undesirable that such an injustice will have happened or might have happened. So I'll leave it at that, but that prospect is not ambiguously understated in this report. Rather, the report says that the impact unlawful income apportionment calculations have on past and future criminal prosecutions for social security debts is a piece of the investigation that the Ombudsman undertook. Now, the Ombudsman at this point doesn't tell us what the nature of that impact was, but it certainly thought it was a live question, and it certainly included it in its investigation. Now, moving beyond the suggestion and beyond the comment, now to the recommendations. And this is really quite a short report. Recommendation 1 in the context of this whole problem is that the Solicitor General be kind of asked by DSS and Services Australia for his opinion on the matter, and the agencies would seek that opinion through the Attorney General, referring the DSS and Services Australia request under the Law Officers Act 1964 on 2 issues. Now, are those issues described? I'm not sure, but it sounds like the Ombudsman had 2 questions that it is recommending be asked. Otherwise, why would it enumerate issues as clearly as it has? It says 2 issues need to be resolved, and we recommend that Services Australia and DSS go to the Attorney General with a request for the Solicitor General's opinion, and that the Attorney General refers that request to the Solicitor General under the Law Officers Act. Now, I'm not sure of the process here. I'd have to review the Law Officers Act, and I probably will if I have time soon. But one question may be whether the request must be made to the Attorney General for the Attorney General to refer it. After all, the Attorney General will have known of this issue and certainly will have read this report. So is it possible for the Attorney General to refer the matter to the Solicitor General, de novo, as it were, or without any request from the agencies? That would probably be clarified or not in the Law Officers Act and the relevant section. But if it is possible that the Attorney General can refer it on their own initiative, one might ask why the Attorney General has not done so, and if he might and should. But that is not a question I have the answer for, so I may be wrong to think that the Attorney General can do that. The second recommendation is actually just a facsimile of the first. It's option B, and it refers to what I was describing before. Alternatively to seeking the Solicitor General's opinion, the Ombudsman is saying that the agencies, DSS and Services Australia, should seek a resolution of this matter via federal court opinion. Now, this is interesting. Does the federal court opinion get expressed as a judgment or as an order or so on, or does it kind of get expressed in some other way and then get referred back to the AAT? Who knows? I think I cover it in that blog a little, but why they use the word opinion rather than federal court, declaration on the law, I'm not sure. But this option B is that the agencies coordinate and seek a federal court opinion, presumably cooperatively with any person seeking administrative appeal through the AAT, under what I know from what I've referred to earlier, that blog post, as Section 45 of the Administrative Appeal Tribunal Act 1975. The Ombudsman doesn't provide the section here, but Section 45 presumably would be the one by which the agencies seek this federal court opinion. And the agencies would do this by identifying a relevant appeal that was already live in the AAT context and, under an arrangement with the appellant, as it were, the applicant in the AAT, they refer the question of law to the federal court under Section 45 of the AAT Act. So now I've referred to the AAT Act, but the report also notes that Section 126 of the SS Admin Act, which is a kind of administrative cousin to the Social Security Act, the principal legislative act, that section allows or permits the DSS secretary and other delegates of the secretary to review a Social Security decision where there is sufficient reason to do so. Now, I'm not sure if that section requires a person to bring that to the attention of the secretary. I don't think they really do. But they've got something like 13,000 to choose from, don't they, as we discovered. So the secretary could point to any one of those 13,000 and say, I want to review that. They could take it to the AAT themselves, presumably. And the applicant would be a respondent. I'm not sure if that works, but it could be the case. Or they could suggest to the person seeking review that they go to the AAT pursuant to a resolution of the broader questions of law that arise here through the federal court. So, I mean, yeah, very interesting. You've got two headline recommendations. One, get the SG's opinion. Two, get the federal court's opinion. And as we'll discover, the SG has actually responded to this already and says, I don't want to give you my opinion. Quite amazing. Now, I'm verbaling the SG here. That's not the terms in which that position is expressed by the SG. But there has been a refusal, as it were. That's too harsh a word, but a declined invitation, put it that way, to review it and for the SG to proffer their opinion at this point in time. Let's go on to recommendation 2. The Ombudsman recommends that DSS and Services Australia amend those instructions, those insufficient instructions that didn't allow reviewers to consider paying money that was not paid, and so forth. And the second part of this recommendation, that the agencies develop a new policy position regarding the Secretary's obligation to initiate a review under Section 126, including in this policy position a list of the factors that the Secretary must, I guess, or should consider when determining when the sufficient reason threshold is met. So at the moment, the sufficient reason threshold must be epically high, and there might be a problem with the Secretary actually taking the initiative to investigate matters because none of them have sufficient reason to do so. Now, one would think that if there is not sufficient reason to investigate after this Ombudsman report, well, then the threshold is presumably, up in the heavens and well beyond any human achievement. So that has to be lower, and the Ombudsman is saying you should list factors to consider when the sufficient reason threshold is met, and you should also describe how to identify, seek, and weigh up those relevant factors. All of this is, of course, in the nature of creating a better pathway through which the Secretary is obligated to initiate review. At the moment, the pathway must be redolent of hurdles and barriers, and it ought to be more accessible. Now, here is the part that I find most perplexing, intriguing, kind of astonishing, to put it at its highest, I suppose. The impact on criminal prosecutions. I've already dealt with it in passing. Let's have a good look at this section. Services Australia refers briefs of evidence to the Commonwealth Director of Public Prosecutions regarding allegations of people intentionally engaging in conduct that resulted in them receiving social security benefits to which they knew they were not entitled. Now, that is not really the nature of the terms of the relevant offence. And to be fair, there are multiple offences that can be charged with respect to people who do not report their income accurately or do not report it at all, and they appear in the Criminal Code under Section 134, Section 135.1, Section 135.2, and you effectively have a range of dishonesty. You have fraudulent and dishonest conduct, then you have a kind of inadvertent dishonest conduct, and then you have conduct which just has some knowledge of disentitlement, but no clear dishonesty or deception being a part of it. Now, most people, it seems to me, and according to the work of my colleague Scarlett Wilcott, who wrote a PhD thesis on these kinds of convictions, and which involved freedom of information kind of records being given to her, and which she published by the CDPP in relation to these offences. It seems to me that most people were charged under the Section 135.2 offence, which does not include dishonesty or deception. And to continue, it says changes to social security debt amounts, including due to those that were kind of calculated due to recalculating known errors in income apportionment calculations, could impact criminal prosecutions that may arise from social security debts. Now, it's put in the present tense here, but it shouldn't be. It should be put in the past tense. It could impact criminal prosecutions that may have arisen from social security debts, such as for fraud or obtaining financial advantage. Okay, so fraud is that deception element, that deceit and dishonesty element. Or they distinguish here, or obtaining financial advantage. That's the one that doesn't involve deception and dishonesty that I was referring to before, and it should be Section 135.2 in this footnote here. Let's have a look. Yep, Section 135.2. So, Services Australia engaged with the CDPP about income apportionment decisions, and which may affect historic, there it is, and future prosecutions. Future prosecutions aren't going to happen on this basis now, surely. It would have to be a royal stuff up for anyone to be prosecuted now in relation to an income apportionment debt. Surely a good lawyer would have an awareness of this report to begin with. A defence lawyer, I mean, but so should a prosecution lawyer and the CDPP. So, federal prosecutor. So, historic debts are really the ones that I think will be affected here, and the Ombudsman writes that at the time of preparing this report, Services Australia actually had not shared all relevant legal advices with the CDPP. So this report was published yesterday, 2 August, and at this time, Services Australia still hasn't given, it seems to me, if I'm reading that correctly, all of the relevant legal advices that it has received over the last 2 years with the CDPP, meaning that the CDPP does not have all the information it needs to understand the scope of the effect of this problem when it comes to past convictions. How many people, once again, who went to jail and lived in jail as a result of a debt that was unlawfully raised via this process? The CDPP itself cannot answer that question until Services Australia provides its legal advices. Maybe it could, but it certainly wouldn't be best equipped to do so. So Services Australia needs to share those advices, in my opinion. And no doubt that's kind of what the Ombudsman thinks too. The Ombudsman continues, we found at the time of our report that Services Australia and DSS did not have a clear strategy agreed with the CDPP about how criminal prosecutions could be affected by changes to administrative debt calculation processes for income apportionment affected decisions. So that means that the agencies do not know anything about what will happen to people who have been referred to the CDPP by those agencies and who have been criminally prosecuted and convicted. This is hugely problematic. Now, let's take the kind of sympathetic devil's advocate position for a moment and lend our sympathy to Services Australia and DSS, which have obviously been overwhelmed by the Robodebt problem. And this has been bubbling away in the background, another thorn in their side. Now that we've given them that sympathy for a little while, let's return to reality and consider the problem here. Services Australia and DSS do not have a clear strategy. They have not got an agreement with the CDPP, no memorandum of understanding, no in principle agreement about how criminal prosecutions could even be affected. They haven't even got a strategy, or at least not a clear one, as to how they could be affected, much less what to do about them once they realise how they could be affected. This is potentially years of waiting for the agencies to get on top of it, unless something else is brought into the equation. Unfortunately, the Solicitor General is waiting for the agencies to come to agreement on the contrary legal advice they have, which I suppose is within, and don't get me wrong, which would be within the rights of the Solicitor General. Far be it from me to kind of presume otherwise. But, you know, as the Ombudsman's report concludes this element of it, in our view, developing a strategy, would assist all parties to ensure future social security debt-related criminal prosecutions and any appeals for previous convictions are based on calculations that are lawful and correct. It would also ensure that the CDPP, who seems to be, as much as the CDPP is involved in these prosecutions, seems here to be the victim of Services Australia and DSS's delays and its reticence to get on top of this. And some of those could be resource oriented, but they could also simply be procrastinatory. It would also ensure, developing this strategy, that the CDPP would be sufficiently informed about the interpretation of Section 107(3)(b) to appropriately undertake its duty to bring significant changes of fact to the attention of individuals in the court. I will have more to say about this, because this is not the first time that unlawful prosecutions and convictions have been brought to the attention of the CDPP, and the CDPP has been in a position to bring those unlawful kind of problems to the attention of individuals in the court. As some of you who may know my previous kind of like agitation in this area will know, that relates to the nature of these Keating-affected matters that emanated from the High Court decision in CDPP and Keating in 2013, by which it was determined that there may be something in the order of 15,000 past criminal convictions rendered unsound by the problem of an unlawful basis for the prosecutions in the period 2001 to 2011-ish. And what did the CDPP do in relation to that? It was a problem because it was just in the changeover period between the Rudd-Gillard-Rudd government and the Abbott government. And unfortunately, the new Abbott government didn't seem to kind of take up the problem. But in the Senate estimates, the senator at the time, Rachel Seward of the Greens, asked the CDPP a question on notice and said, are you going to inform individuals or bring to the attention of individuals or a court the problem of unlawfulness in relation to certain debts that and convictions in the order of about 15,000 potential estimated convictions, or not? And the CDPP said simply, well, anyone who may be affected by this case, the Keating case, is free to get in touch. So I hope we don't see a repeat of that, where the CDPP, once it does get all the information to be sufficiently informed about the interpretation of Section 1073B, and presuming that information unassailably confirms that many convictions or some convictions have been unlawful, ultra vires, as it were, that they've been prosecuted and convicted without relevant legal authority or power, would bring that to the attention of the individual who was prosecuted and convicted. But there is precedent for the CDPP doing exactly the opposite. In other words, not bringing that to the attention of individuals, much less the court, but rather sitting back and passively waiting for individuals to discover that they might have had a conviction prosecuted against them and without a basis in law, and playing this passive role of responding on a case-by-case basis to inquiries. I find it very interesting that the Ombudsman presumes that the CDPP has a duty to bring significant changes of fact to the attention of individuals, because historically the CDPP has not discharged such a duty, if it exists, to bring significant changes of fact to the attention of individuals. On the contrary, it has passively waited for individuals to inquire whether there has been any mistake and unlawful conviction against them. And I can talk about that another time. You know, it has been a little while. I'll quickly get to the end of these recommendations before I conclude this video, and I might make a few more videos to follow up, but you know, the part that I won't get to today is the actual methodological problem, the technical reason why income apportionment is unlawful. But it does relate to this Section 1073B and what it provides for, and the nature of the calculations that occurred by virtue of Centrelink's internal calculation tool, which was at variance with the requirements of Section 1073B. Okay, so recommendation 3 is that the agencies, Services Australia and DSS and the CDPP, collectively develop a strategy for how they will approach historic, current and future criminal prosecutions associated with administrative debts involving income apportionment under Section 1073B of the Social Security Act 1991, going back to 2003. 20 years of potential unlawful convictions. Please, SA, DSS and CDPP, consult and develop a strategy. That's what the Ombudsman is asking for. Isn't that another mild recommendation? Please think about how to deal with this. Please write down a flow chart potentially. It has to happen. It is unthinkable that inaction continues in this area in a rules-based democracy like Australia. I mean, the rule of law and the principle of legality is, subject to, insult if this is delayed anymore. That's my view. Recommendation 4, provide documents to the CDPP. The Ombudsman is recommending that Services Australia and DSS provide the CDPP with copies of the Solicitor General's opinion if they can obtain it. Now, as I noted, the SG isn't prepared to give it to the agencies quite just yet. 2, copies of all draft and finalised legal advices on Section 1073B, because of course the agencies haven't given the CDPP those finalised legal advices. Why not? And I think only SA has deprived the CDPP of it. Always SA, always DHS, isn't it? As we saw in Robodebt, it wasn't DSS some of the time, or mainly most of the time. It was DHS. And then thirdly, provide to the CDPP the Ombudsman's finalised investigation report, including any formal responses from DSS and Services Australia. Is that a finalised investigation report that is to come in the future? Or have they got another report at the moment? I doubt it, because the investigation is ongoing. And while I'm on that point, let's go back up, because I did mention it before and I haven't really clarified it. But the ongoing investigation is identified here. You can see at this Précis page, highlights, why did we investigate? The Ombudsman decided to conduct 2 investigations. 1, lawfulness of the agency's approach to income apportionment. That seems to have been concluded. This statement relates to investigation 1. Obviously, there's a broader investigative report, and because this is just a very short kind of summary, it seems. It's only 7 or 8 pages. But that investigation seems to have concluded because it is stated with no uncertainty in this report that it is unlawful. So if the question was, is it lawful? That question is answered by the Ombudsman with this report. Now, Investigation 2 is the ongoing report. Investigation 2 examines the agency's administration of income apportionment decisions, their communication with customers, their handling of complaints, their internal reviews and AAT or federal court appeals. So the Investigation 2 is effectively, what did the agencies do in the context of the lawfulness problem being presented to them? And what have they done even prior to the Ombudsman getting involved, I assume. That investigation is ongoing. So I'm looking forward to a report of that investigation in which the Ombudsman, no doubt, criticises the agencies, as they have done in this report, for delay, dithering, all the rest. I haven't even begun to consider the potential here for CCDA claims, that they being claims for defective administration by a department such as DSS or Services Australia. Can you just imagine if people have gone to prison for debts involving income apportionment? And, you know, I don't think we need to imagine, because, you know, I am aware of people who have received convictions. To be fair, I don't know of anyone specifically who has gone to prison, although I have a few vague memories of people who have gone to prison and whose debts might have been affected by income apportionment. But I certainly know of, I won't put a number on it, but I certainly am aware of at least one And I say that number because I can prove it here and now. Well, I can't prove it, but I have information to share here and now about that person's records, de-identified, who had a criminal conviction recorded against their name, and part of the debt for which they were criminally prosecuted was affected, as far as I can tell, which I think is not too bad, by income apportionment. Okay, here it is. Here's the casual earnings apportionment tool that the individual was able to access via the Freedom of Information Act. And here are the verified earnings details that the employer would have supplied to Centrelink. In this first entry here, you can see that the person earned between the 1st of August 2004 and the 30th of November 2004 an amount $302.50. Now look at the period over which this amount is earned, or within which this amount is earned. From August to November, from March, April, May, June, July, August, September, October, November, that's over, about 3 to 4 months. They have earned only that $382. That's 122 days. The casual earnings apportionment calculator converts that amount into a daily rate of $3.14. That daily rate is then multiplied by 14 days for the relevant fortnights in which it is said to have been earned, and those relevant entitlement fortnights or Centrelink fortnights, which are described as such in the Ombudsman's report, are recorded in these columns here. First thing you'll note is that the 1st of the 8th is the start date, and that's not aligned with any start date of an entitlement period. So you've got this synchronicity problem of when the income was earned starting on the 1st of August and the entitlement period starting on the 5th of August. So you can't align those, which means that the daily rate actually goes back in time, so that this fortnight includes a daily rate calculated from the 1st of August to the 5th of August, which is, 1, 2, 3, 4 days, or 4 or 5 days, rather, 5 days. 5 times $3.14 is $15.68. So you've there got that apportionment happening in that first fortnight. Then it goes through to the second fortnight. So again, you've got 14 times 3 is $43.89 for the second fortnight. 14 times $3.14 for the third fortnight is $43.89, etc., etc. I cannot think of how this is not income apportionment as described in the Ombudsman's report, because you've got successive fortnights over which income is apportioned, which was the description of what income apportionment is. Now, I think this has happened lots, because here's your earnings given by the employer to Centrelink. The employer doesn't have fortnightly records for this amount. It's, and it has a weekly record for this second amount, or this second amount was paid over 4 days with a daily rate of $148. So they'd have to muck around with this amount too. And again, you do not have these starting dates for these periods. Look at this, 27th of the 1st, 2005 to 28th of the 1st, 2005. That's 2 days in which $278.40 was earned, which results in a daily rate of $139.20. I mean, it's so commonplace for the earning periods, here they're not fortnights, to be, upon being converted to the entitlement periods, distorted in a way that requires so much fudging. And in order to make it right, in the absence of detail, Centrelink has done this income apportionment. That's what it is. It is, as I described at the head of the video, a process by which you're converting insufficiently detailed reports from an employer or from a person who reports their income to Centrelink as best as they can, because they might earn it in periods other than fortnights. They might use a form, as is noted in the Ombudsman's report, to convert it themselves. But that brings into view another question. Did people self-apportion their income? I mean, that'd be a big problem, because if they self-apportioned, Centrelink would be innocent in a way, because they're just converting the reported pre-apportioned income into their calculator. They wouldn't be committing the vice, and the vice might not be even detectable. But in instances where the income reports come in from the employer or the individual, and they are not consistent and nice and tidily aligning with the entitlement periods that the legislation requires debts to be calculated within, namely fortnightly periods determined by the happenstance date on which the Centrelink payment approved is paid to the person. So if you apply for Centrelink payments and you get it from commencing the 23rd of July, for example, as is the case here, then the nature of that starting date might be random, but it's very likely to be disaligned from your payslip dates. And so you will always potentially have a problem of your income not aligning with the entitlement periods, which means it has to be reduced to a daily rate. But it is only lawful, on my reading of the problem, if the apportionment occurs within that fortnight, within the two dates constituting the bounds of the entitlement period. You can reduce a payment to a daily rate, lawfully it seems, within the entitlement period, so that the person earned $3.14 every day within this fortnight, but the successive fortnight has to be calculated on a different basis, based on the specific detailed income received in that fortnight. Now, it could be, although I really don't think it's possible, it could conceivably be possible, although I really don't think it's probable, I should say, or really likely at all, or really probable, or somewhere between probable and possible. But it could be by sheer chance and chaotic kind of serendipity that someone who has had income apportionment also earned the same amount in these successive fortnights. But just like Robodebt, it's just unbelievable that a person who is employed casually would have the exact same hours over fortnight after fortnight after fortnight at the exact same rate of pay, because sometimes they might work a shift on a Sunday and get penalty rates, and another fortnight they might not. The problem at the heart of a lot of the calculation kind of fiasco that Robodebt and now this represents over the last 20 years plus of Centrelink administration is that casual earners do not have consistent income. That problem results in a calculation error when Centrelink seeks to fill in details that are not available with respect to the income reports it receives, or in the case of Robodebt, the ATO data it receives about what that person's earnings were. So this is an example of income apportionment in my view, and apportionment is not kind of something new at all. The actual tool, which is a form of macro-enabled Excel spreadsheet, as we can see here, that Centrelink use or have used in various, variations, and I don't have a variation number on the bottom of this or a kind of version number, but there have been different versions of every one of the tools they use. But this tool is called the Casual Earnings Apportionment tool. And so apportionment is not some kind of phenomenon observed by, the Ombudsman now and named as such kind of in the absence of any specific kind of, descriptor. Rather, apportionment is exactly what has been kind of expressly done through an apportionment tool for 20 years. Now, the Ombudsman has made a point to say that the agencies were genuinely mistaken, that they made a genuine mistake about the law. They thought this was lawful. And I don't want to make any admissions or cast any aspersions, but how could it be otherwise? Because the actual tool expressly says that it is doing apportionment. And when you look at the tool and the way it calculates debts, it's plain as day that it's doing something odd and artificial. Because how could a person earn the same amount fortnight after fortnight to the cent? And let's make it even more common sense. Who earns $43.89 a fortnight? Minimum wage is probably between $15 and $20, maybe a bit less in 2004, but that would mean that a person is working 1.5 hours potentially every fortnight as a casual employee to the minute, over a period of 2 months. It's just clear. And look at this, you got $15.68 here, and then you got $15.68 here. It's a mathematical kind of fiction. That's the problem. So when I looked for the words casual apportionment in the AAT decisions, I only got 2 hits on my preliminary OSTLE research. Judd and Secretary, these are obviously AA2 decisions, contains a reference to income apportionment. I thought it did. Maybe it doesn't. I mean, it refers to apportioned earnings all throughout. Before apportioning and apportionment of income in a manner consistent with the existing approach from cases such as Harris and Rowley. You can see that apportionment is nothing new, although this case is very recent. What is it? 2022. So you can see the issue of income apportionment is arising in the AAT recently. Okay. And the tool that I was referring to and had on screen earlier, the Casual Earnings Apportionment tool, is referred to directly here. And quoted material from this AAT decision in italics here talks about multi-cal calculations, which is a different tool used by Centrelink, and the verified earnings detail sheet in the Casual Earnings Apportionment table, which is part of the multi-cal tools. So these tools are well known to the AAT. They're clearly well known to Centrelink. They're the ones they've been using for many decades, 2 decades at least, in various versions. Okay, so I mean, yep, nothing more to be said. This is perfectly mundane, everyday stuff for Centrelink to have done this for 20 years. It just turns out that there was no legal authority to do it. The other decision is Drury and Secretary, which goes back to 2017. If I'm not mistaken, it only refers to apportionment. Well, here it talks about where a person is a pay-as-you-go, etc., regardless of whether the amount of income in each fortnight varies, the Act provides for Centrelink to apportion income across a fortnight period, and it refers here to 107.3b and 107.3c. Now, it seems that this paragraph, without doing much further analysis, this is back in 2017, so actually before the Robodebt class action and before a lot of the momentum for Robodebt began. Regardless, it seems that this AAT decision might be erroneous, at least insofar as the member, DK Grigg, interprets the 107(3) capital B to lawfully provide for apportionment, as is stated to be the case here. It seems to me that 107(3)B, the prior to 2020 version of that provision, doesn't allow for apportionment. So it seems that there has been an error of legal construction here related to whether section 107(3)B and 107(3)C of the Act permits the apportionment that was purported to be legal under those same provisions prior to the statement we see in the Ombudsman's report that it is unlawful. Okay, so they're the two decisions I could find that refer to income apportionment. The other notable document that talks about it quite a bit that I found earlier today is from the 2021 Senate Standing Committee hearing where the Rex Patrick concerns were raised. Here in this document, which was an answer to a question on notice, the question was asked by Deborah O'Neill and the answer was given by Services Australia in the form of two AAT decisions that were heard both in the first and second tier, the first tier being a kind of unpublished tier, the second tier having published records of the decisions. And those two decisions are summarised and then they're attached. And it is in these decisions that we see the casual earnings apportionment tool being referenced several times. So we know what that is now because I've shown you it. I've showed you it. This is the casual earnings apportionment tool, and I've showed you how casual earnings apportionment looks. It looks like this: successive fortnights, more than one or at least two, in which you have the same figure, and that is not a correct figure with respect to the actual earnings. That's basically what it is. So if anyone wanted to investigate whether their debt had been subject to unlawful casual earnings apportionment, they would have to request under the FOI Act a complete copy of their debt file from Centrelink, and they would then, upon receiving it, want to look at the casual earnings apportionment tool and keep an eye out for duplicates of the same number in the entitlement column of the entitlement periods here. And where you had duplicates across 2 fortnights or more, you have a very good prima facie kind of indication that casual earnings apportionment, now said to be unlawful, has occurred. So that was the final recommendation, going back to where we were on the Ombudsman's report now, that the Ombudsman, or that the agencies and CDPP are all apprised of each other's documents, and that they are all apprised as the need arises of documents that may come into existence, including the SG's opinion and including the finalised investigation report, either for investigation 1 or investigation 2, with respect to this problem, the problem of income apportionment. Okay, so I think I'll leave it at that. My video is 1 hour and 43 minutes. So if you've come this far, you are probably one of a select few. And I appreciate your attention and interest in this. I will make a follow-up video in which I go into a few more things. I'll probably just continue with my analysis of this report, even though there's only a few pages left. But what I will do is try and give a more thorough, if I can, explanation as to why it is unlawful. Because what I'll do, and it's not too hard to do, is pull up the provision 107.3b and its requirements, and then I'll show you once again what Centrelink did. And when we see those two things side by side, it'll be clear why there was no lawful basis for income apportionment. So without further ado, I'll close the vodcast or the video here, and we'll see you soon. Ciao.